Hello all, welcome back to my channel Learn and Have Fun with Krisha, and today we will be doing the last video in the series of the main organ of the Indian government, and that is the judiciary. Before we move on, let us see the three different branches of the government. So we have already studied the central legislature and the union executive, and in this last video we'll be studying the judiciary. So let us begin. Let me just introduce you to this topic. The Indian judicial system is one of the oldest legal systems in the world today. The framework of the current legal system has been laid down by the Indian Constitution, and the judicial system derives its powers from it. An independent judiciary is essential for any government. India too has a single unified judiciary, and all the courts interpret, safeguard, and enforce the laws made by the legislature at the center. Of course, at the state. The Supreme Court, located in New Delhi, is the highest court in India, followed by the high courts in the state and then the district courts. Let us see the structure of the courts in India. First, we have the Supreme Court of India at the topmost, then the High Court, the subordinate courts, which are revenue courts, Nyaya Panchayats, district courts, and Lok Adalats. Now, the Nyaya Panchayat have two types of cases. One is the civil cases and the other is the criminal cases. Moving on. This is how the Constitution of India looks. The Constitution of India is the supreme law of the country. It lays down the powers, duties, and procedures and structure of the judicial system. The Supreme Court of India came into being on 28th January 1950. It holds the position of being the apex court of law, or the apex court of law, that is the main or the center. The Supreme Court consists of Chief Justice and other judges, the number of which does not exceed 31 judges. This is Mr. Sharad Arvind Bobde, who is the current Chief Justice of India. He was appointed by Ramnath Kovind, the President of India, on 18 November 2019. Presently, the strength of the Supreme Court of India is 31, including the Chief Justice of India. Let us see the qualifications required to be a judge or a Chief Justice in the Supreme Court of India. He must be a citizen of India. He must be a judge of the High Court for at least 5 years at a stretch. He must have been an advocate of a high court or of two or more courts continuously for at least 10 years. He must be a well-known jurist in the eyes of the President. Moving on, let us see the appointment. The Chief Justice and other judges are appointed by the President. While appointing the Chief Justice, the judges of the Supreme Court and the Council of Ministers at the center are consulted. The Chief Justice and the Council of Ministers are consulted in the appointment of the judges for the Supreme Court. The salaries. The salaries of the Chief Justice and the other judges are decided by the Parliament. The Chief Justice gets a salary of 1 lakh along with other facilities like a furnished house, car, etc. Now, this amount has now been changed to 2.8 lakh per month. The judges receive a monthly salary of 90,000 plus DA and other facilities. This amount, that is the 90,000, has been changed to 2.5 lakhs per month now. Let us see the term now. Both the Chief Justice and the judges can work till the age of 65. Their services cannot be terminated, but they can resign from their post on their own. If the judge of the Supreme Court misuses his position or acts against the Constitution, he or she can be impeached. A judge cannot practice after his or her retirement. Moving on to the High Courts. The Constitution of India provides a High Court in every state. It is the highest judicial authority in a state and consists of a Chief Justice and judges as decided by the President. This is the Mumbai High Court. Let us see the qualifications needed. He or she must be a citizen of India. he or she should have held her judicial office in India for at least 10 years. He or she should have worked as an advocate in any of the high courts in India for 10 years. He should be a teacher at a law college. He or she should be a well-known jurist or writer of law books. Moving on to the appointment. After consulting the Chief Justice of the Supreme Court and the Governor of the state, the President appoints the Chief Justice of the High Court. The judges, however, are appointed by the President after the consultation of the Chief Justice of the concerned High Court. Moving on to the pay and allowances of the judges and Chief Justice of the High Courts. The Chief Justice of a High Court gets approximately 90,000 plus DA along with other allowances concerned as salary. He also gets a fully furnished house free of cost. This amount, that is 90,000, has now been changed to 2.5 lakh per month. The judges get a salary of 80,000 plus DA and other allowances. They are also provided free residential accommodation by the government. This 80,000 amount has now been changed to 2.25 lakh per month. The pay and allowances cannot be changed while they are still in service. Moving on to the jurisdiction of judiciary. The Supreme Court is a powerful judiciary. The Constitution of India has detailed its jurisdiction and powers. The Supreme Court of India has a wider jurisdiction than any other Supreme Court in any other part of the world. Let us see the different jurisdictions of the Supreme Court of India. First one is the original jurisdiction, appellate jurisdiction, advisory jurisdiction, revisory jurisdiction, judicial review, court of record, and writ jurisdiction. Let us begin with original jurisdiction. The original jurisdiction of a court is the power to hear a case for the first time. As per the Constitution of India, the Supreme Court shall have original jurisdiction in any dispute between the Government of India and one or more states, or the Government of India and any state, or two or more states. So it can happen in any of these cases. Moving on to the appellate jurisdiction. It is the power of a high court to review decisions and change outcomes of decisions of lower courts. As the Court of Appeal, the Supreme Court is the final appellate tribunal of our country. Moving on to advisory jurisdiction. One of the salient features of the Supreme Court of India is its consultative role. The President can refer to the court either a question of law or a question of fact, provided that it is of public importance. However, it is not compulsory for the court to give its advice. Moving on to revisory jurisdiction. The Supreme Court under Article 137 is empowered to review a judgment or order made by it with a view to remove any mistake or error that might have crept in the judgment or orders. This means that even though all the judgment and orders are passed by Supreme Court and binding on all courts of India, they are not binding on the Supreme Court. Moving on to judicial review. Judicial review refers to the power of the judiciary to interpret the Constitution and to declare any such law or order of the legislature and executive void if it finds them in conflict with the Constitution of India. It can be exercised both by the Supreme Court and the High Courts. Laws made by the centre and the state government come under review by judiciary. Moving on to Court of Record. Both the Supreme Courts and High Courts are said to be the courts of record. It means that all their acts and proceedings are kept as a record and testimony to be referred to in future in giving judgment. These records are used with a high authority and their truth cannot be questioned. Article 129 of the Constitution of India makes the Supreme Court the court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Article 215 empowers the High Court of the states to be the courts of record. Moving on to the last one, that is the writ jurisdiction. Article 32 imposes duty on the Supreme Court to enforce the fundamental rights. Under this article, every individual has the right to move the Supreme Court directly if there has been any infringement on its fundamental rights. The writ jurisdiction is also referred to as the original jurisdiction of the Supreme Court. Now, before we move on to the different writs, let me first tell you what is a writ. A writ is a formal written order issued by a court, such as any warrant, orders, and directions. These are issued by the Supreme Court or the High Court. And there are 5 major types of writs. We will be seeing them further. So we have habeas corpus, which is an order through which the court can cause any person who has been detained or imprisoned to be physically brought before the court. The court then examines the reason of his detention, and if there is no legal justification of his detention, he can be set free. Such a writ can be issued when a person is detained and not produced before the magistrate within 24 hours, or when the person is arrested without any violation of law, or when the person is arrested under a law which is unconstitutional, means that is no more there, or when detention is done to harm the person. So it can happen in any of these cases. Moving on to the second one, that is mandamus. The word mandamus means awakening call, and it awakens the sleeping authorities to perform their duty. So this writ is a command issued by the government, issued by a court to a public official, public body, corporation, lower court, or the government, asking them to perform the duties which they have refused to perform. Moving on to the third one, that is prohibition. It is an order through which the Supreme Court and High Courts may prohibit the lower courts, such as the special tribunals, magistrates, commissions, and other judiciary officers who go beyond their jurisdiction or act contrary to the rule of natural justice. For example, if a judicial officer has personal interest in a case, it may hamper the decision and the course of natural justice. Moving on to the next one, that is certiorari. Okay, so certiorari is a writ that orders to move a case from a lower to a higher court. It is issued by a higher court to a lower court, either to transfer a case pending with that to itself or stop its order. This is generally done because superior court believes that either the inferior court has no jurisdiction or committed an error of law. The last one, that is quo warranto. Quo warranto is issued to inquire into legality of the claim of a person or public office. It restricts the person or authority to act in an office which he or she is not entitled to. This writ is applicable to the public offices only and not to the private offices. Moving with this, we move on to the functions of judiciary. The judiciary has 8 functions that we will be seeing. First is judiciary prevents violation of law. It decides on constitutional questions. It interprets the constitution and laws. It also undertakes some administrative functions like appointment of officers and servants, maintenance of records, administration of staff, etc. The highest court of the country sometimes gives advice to the executive and legislature on constitutional points if sought for. Judiciary is the protector of fundamental rights. It is the guardian and custodian of the Constitution. It works as a court of record. Moving on to the importance of judiciary. It protects the fundamental rights of the citizens. It settles disputes between the center and the states. It assists the president or the governor in legal matters. It helps in interpreting the constitution. The judiciary keeps a control over the executive and the legislature. Now let us see the parallelism between the Supreme Court and the High Court. The Supreme Court is the highest court in India, while the High Court is the highest court of the state. The Supreme Court consists of Chief Justice and 31 other judges, while the High Court consists of Chief Justice and judges. So the Supreme Court, the age of retirement is 65 years, while for the High Court, the age of retirement was 62 years, which is now raised to 65 years. Now let us see the functions of the Supreme Court. Original jurisdiction, appellate jurisdiction, advisory jurisdiction, revisory jurisdiction, guardian of fundamental rights, and court of record. And the functions of the High Court are original jurisdiction, appellate jurisdiction, advisory jurisdiction, revisory jurisdiction, and court of record. So all of them are same except this one, that is an addition to the Supreme Court, that is the guardian of fundamental rights. With this, I would like to conclude. Thank you for watching my video, and don't forget to subscribe, like, and share. There is an assessment link in the description box as well as in the comments. Do check it out. You can find it here also. Thank you.